Bulboaca Asociatii podcast.
Hello everyone. The economic consequences generated by COVID-19 pandemics are without precedent. The rapid contraction of the economy, the decline of revenues, the increased payment delays, the increase of the unemployment rate have forced most European governments to undertake urgent measures in all areas by temporarily amending various legal frameworks, including the one for the insolvency proceedings. Which are the main amendments to the Insolvency Law in Romania, brought by Law 113/2020? May this be considered tools for both the creditors and the debtors that can prove to be useful in these difficult times? Will we see a rise or a drop in the insolvency cases? On today's edition, with a glimpse in the past and the peek in the future, we'll address the prior mentioned aspects with our guest, Andreea Hlihor, partner within Bulboaca Asociatii. Hi, Andreea.
Hi, Nicolae.
Thank you for being here. Please tell me, is there any official data regarding the evolution of the insolvency cases in 2020 in Romania, especially during the state of emergency or alert? And after that, we will discuss about the most important amendments on the insolvency law.
Thank you very much for the invitation. These amendments are quite important. Of course, there is an official data. And the evolution of the insolvency cases in 2020 may be connected to the amendments brought to the insolvency law. So, information on the cases regarding these insolvency procedures is found on the website of the National Trade Register Office. Currently, according to the information released by the authority at the end of May 2020, there are registered about 1,600 cases, with 1,000 less than at the end of May 2019. During the emergency state in Romania, the number of cases registered in March reaches about 460 cases, while in April only 72 and in May 244. So, comparing the figures with the ones registered in 2019, in March there were 523 cases, in April around 560 cases, and in May around 567 cases. We can say that there are significant differences between the insolvencies registered this year as compared to the previous year, taking into consideration, of course, the same periods. The reason behind the decrease in number is strongly connected to the amendments brought to the insolvency law.
Andreea, can you please explain why these figures are lower than before and how did the amendments influence the decrease? And moreover, considering that the number is reduced, this may be considered a good sign with positive effects on the recovery of the economy. Is this true?
I would like to believe that, but unfortunately, I cannot shed an optimistic light over the situation, namely on the lowering of the insolvency cases, due to several reasons that I will further develop. Among the legal provisions amended in this period were the one referring to the obligation of the legal representatives of the company to file for insolvency within 30 days as of the occurrence of the insolvency state. Currently, the debtor is not obliged to file for insolvency during the alert state, but has the possibility to undertake such legal action. So, in Romania, the alert state has been prolonged with another 30 days, as of 17 June 2020, of course. And also, it is very important to mention another aspect, that creditors may file for insolvency only if they have evidence that they have tried to conclude a payment convention with the debtor prior to submitting any insolvency requests. Also, according to the latest amendments brought by Law 113 per 2020, there is an increase of the minimum amount from 40,000 lei to 50,000 lei for the submission of the request regarding the entrance into insolvency procedures. You have to know that similar legal provisions were adopted in Germany, Spain, France, Italy, I guess, and all of them having as purpose, of course, help for companies in their attempt to try and cope with these difficult times. As such, considering at this point, if you look at it, that filing for insolvency is a voluntary process and no longer an obligation, payment conventions, you know that they usually imply a long period of time for negotiation. And the fact that the amount for filing the insolvency request was increased, I think that it is out of the question why we are facing a lower number of insolvency cases than before, and the numbers, be careful, they are misleading. I think they are misleading. Basically, I think that at this point, only the most distressed companies have filed for insolvency, considering their very low chances of recovery, which are most probably on the verge of bankruptcy.
And do you think that we should expect an increase of the insolvency cases in the future?
Actually, I do. So considering that we are talking about temporary measures within the insolvency legal framework, and not only, and that certain advantages granted during this period, such as deferrals for payment of taxes or loans granted by banks, are also limited in time, it is hard to imagine that we will not have a substantial growth in the number of insolvency cases, but not only in Romania, also in the other European countries.
Okay, thank you. So returning to the main amendments brought by Law 113 per 2020 to the Insolvency Law. We've discussed about one of the most recent amendments, namely the increase of the minimum amount for filing the insolvency request. What other amendments were provided?
So, one important amendment regards the removal of that condition with respect to the necessity of an amount of the budgetary claims lower than 50% from the total claims whenever the request regarding the entrance into insolvency is submitted by the debtor, removing also some practical impediments. So, the former version of the legal provision, although aiming to protect the budgetary creditor, placed that debtor, which was facing insolvency and where the total amount of the budgetary claims was higher than 50%, into great difficulty regarding the possibility to file for insolvency. On the other hand, the former versions led to the inapplicability of the legal provisions regarding the debtor's obligation to file for insolvency within 30 days as of the date of the insolvency state occurred.
But I think this is not the only amendment that hazeled certain worries about the budgetary creditors, isn't it?
Yeah, it seems that you are quite familiar with the recent amendments. Yes, indeed. In practice, there were certain problems that were clarified by the current amendments. An important problem that led to a great deal of different rulings is represented by the situation where haircuts were made to claims within the reorganization plan. As such, it was considered that any reduction of the claims is assimilated to an income for the insolvent debtor that needs to be subject to tax, and the fiscal authorities almost every time consider that this category of budgetary claims are current and needed to be paid with priority. According to the current provisions in the section regarding the closing of the insolvency procedure, the situation is clarified. So it is expressly stated that this type of budgetary claims are due as of the day the reorganization procedure is closed, but only followed by the performance of the debtor's activity or the liquidation procedure following a plan is closed. These aspects need to be attested by a court's decision, and that decision needs to be based on the report of the insolvency practitioner that confirms the full observance of all payment obligations established through the confirmed plan and also of the due current claims.
Among these amendments, are there any new concepts introduced that might prove useful for the participants?
Well, actually, I could not say that there are new concepts as they were previously known especially in practice. But I'm referring in particular to the need of the legislator to provide a definition for the payment agreement. As I said, so the payment agreement is not something new within the insolvency context. References are made within other legal provisions of the insolvency law, where it is stated that a payment agreement will lead, for example, to the dismissal of the bankruptcy request submitted by the creditor who has concluded the payment agreement, even though the debtor does not observe the reorganization plan or it accumulated new debts during the insolvency procedure. And another case is where a payment agreement will lead to the dismissal of the bankruptcy request submitted by the creditor of a claim which is current, certain, liquid, and due for more than 60 days, that concluded the payment agreement with the debtor, and that has a claim which represents more than the minimum provided under the legal provisions, those 50,000 lei that I've mentioned before. However, the legislator has considered necessary providing a definition for the payment agreement, and namely as the understanding between the debtor and the creditor regarding the payment in one or more installments with different due dates according to the contractual or legal provisions. So it is a little bit questionable if this payment agreement, as currently defined, may intervene in any stage of the insolvency procedure, namely in the hypothetical situation where the debtor is subject to reorganization and the reorganization plan is in place, approved by the creditors and confirmed by the syndic judge. Any payment agreement which might be considered in the reorganization stage should not prejudice the rights of other creditors, participants to the same insolvency procedures, and should not breach the legal provisions of the insolvency law that provide the conditions to be met for the fair and equitable treatment of the existing creditors. Considering the above, a special role will play the insolvency practitioner that has acknowledged the existence of a payment agreement and needs to ensure the full observance of the principles which are set by the insolvency law.
Okay, and as a personal opinion from you, do you think that the insolvency practitioners welcome these amendments?
I'm sure that they do. They have the purpose to clarify some past practices, although some amendments place a larger responsibility on their shoulders, as I mentioned before and we previously discussed about, the one regarding the payment conventions. In addition, there are two other amendments that basically help the practitioners in the procedure. One of them regards the date and deadline in which the insolvency practitioner needs to analyze the payment requests submitted by the creditors holding claims which are born after the opening of the insolvency procedure. So as per current provisions, the insolvency practitioner needs to verify the grounds for the payment requests only if they were communicated with confirmation receipts by the interested creditors and not if they were simply communicated as provided under the former legal provisions. Now, in addition, the deadline for the analysis is increased from 10 to 15 days as of the date of the receipt. Also, a very important amendment is the removal of the creditor's right to file for enforcement proceedings for the claims born after the opening of the insolvency proceedings and which were due more than 60 days. These provisions seem to be justified considering the insolvency context, as insolvency proceedings were meant to be incompatible with other procedures for the recovery of claims against an insolvent company. The former provisions basically granted the unfolding of two parallel proceedings aiming the recovery of the debts, breaching the principles that govern the insolvency proceedings. Another helpful amendment regards the content of the offers that insolvency practitioners need to submit in court in order to be provisory appointed. According to the current legal provisions, insolvency practitioners are no longer obliged to provide evidence regarding the time and human resources to be allocated. and also their general or specific experience necessary to managing the insolvency file. The discretionary power of the syndic judge in appointing an insolvency practitioner being removed.
Okay, can you please make a general conclusion over this new law?
As a general appreciation, the amendments brought by this new law are welcome, have a clarifying and useful role. I could say that they are closer to the purpose for which the insolvency law was adopted and of the principles set by this law. Certainly, the way in which these provisions will be implemented in practice will indicate the efficiency of the measures that have been undertaken.
Okay, thank you so much, Andreea.
Thank you very much, Nicolae, for the invitation.
Ladies and gentlemen, our podcast stops here. Our guest today was Andreea Hlihor, partner within Bulboaca Associatii. We invite you to explore our social media channels and also our website, bulboaca.com. Thank you for your attention. All the best from us.